Please, Your Lordship. My Lord, I beg to mention item number 13 on behalf of state respondents. I'm appearing on behalf of Mr. K.P. Bhattacharjee, my Lord, who is the counsel for the state in this matter.
Yes, who's appearing for the...
My Lord, Mr. Sinkon, Mr. N. Sinkon, my Lord. We have, I believe, my Lord, we have informed them also. Is he ready for the matter? Number 13, Joel Singh. Yes.
The written statement has to be filed with state.
Yes. My Lord, we are at the stage of filing of written argument here. Mr. KP couldn't file, my Lord. He has, my Lord, his Mrs. met with a minor accident, my Lord. So he couldn't come. He's indisposed for the day. So my Lord can accommodate some more time.
On pre-made by the respondent, state respondent, this is matter up to 2 weeks.
Highly obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 10, Your Lordship. The conducting counsel for this matter is outstation, Your Lordship, because his grandmother expired, Your Lordship.
You're appearing for?
I'm appearing for on behalf of Mr. S. Deb. I'm for the petitioner.
Yes.
I'm appearing for state respondents, Lord.
For the private respondents, 7 and 11.
On pre-made by the petitioner, on grounds of indisposition of the letter conducting counsel, that is adjourned. This is up to 1 week.
2 weeks, Your Lordship. 2 weeks, Your Lordship, because after 2 weeks he'll be coming, Your Lordship.
2 weeks.
Lordship, I beg to mention item number 17 on behalf of the respondent.
You're for?
Respondent, Your Lordship, on behalf of SSG.
Petitioner.
On pre-made by the respondent, this is matter up to 2 weeks.
Your Lordship, similar prayer for item number 15, Your Lordship.
I'm for the petitioner, Lordship. No objection, Lordship.
On pre-made by the respondent,
3 to 5, Your Lordship.
3 to 5. Not objected to by petitioner. This is matter up to 2 weeks.
Much obliged, Your Lordship. Your Lordship, it's for item number 12, Your Lordship. Your Lordship, I'm from the petitioner, Your Lordship. On Your Lordship, we need for 1 week time since the conducting counsel S. Kumar is having high fever, Your Lordship. So we need 1 week time.
Please, yes, Lordship. I'm here for the government, Lordship. As per the last order, Lordship had directed me to send back the CD and to bring it back on today's date.
What do we do? Prayer Smith for?
Lordship, if may please, Lordship, since if I may, Lordship, if I can make a full copy of the CD and then I can keep the full copy and...
More often than not, this court has indicated that you can do it.
Lordship.
Not necessarily that you bring the original every now and then.
Lordship.
You photocopy it, and if there are additions to it, you can of course bring it later on.
Lordship.
How long?
1 week time, Lordship.
On pre-made by the petitioner, this is matter up to 1 week.
Much obliged.
Yes.
Item number 8, my lord. Here the written argument, my lord has said that written argument we are filing on the next day. This is matter pertains to ACP and MSCP.
Yes, so
we are filing the written argument.
have you filed?
We have prepared, my lord. Certain judgments I have to look.
Have you filed yours?
We have not filed one.
On pre-made by the petitioner, seeking time for filing of the written argument, seems allowed. How long?
1 week, my lord.
This is matter to 1 week.
2 weeks. We have 2 weeks.
Hmm?
We have 2 weeks.
2 weeks. But do it.
Yes, definitely, my lord.
Obliged.
May I please, Lordship? I'd like to mention item number 16, Lordship. in this case, Lordship, the Union of India has preferred an SLP before the Honorable Supreme Court, and that matter is listed today. So,
No, what is the matter about?
Commission matter.
P commission.
Lordship. So, matter may come up after
Assam
2
rifle
weeks,
matters.
Lordship.
Assam rifle matters.
My lord, the batch of matters, my lord. The lordship will decide in division bench.
Okay.
SLP has been filed, my lord. The notice was issued, my lord. It was supposed to be listed today.
Yes. 2 weeks, Lordship.
On premier by the parties, let's this matter to 2 weeks. Excuse me.
Daily cost list item number 1.
May it please the Lordships.
Yes.
Well, as the Lordship will allow me just a preliminary point. This is also a quashing matter 482. Well, I've carefully heard your Lordship's observations in the previous matter, so I will keep that in mind. Well, I only want to say one thing. The background of this case, my lords, is somewhat broad. Your lordships probably are aware matter travelled from the High Court, and then consequentially the FIR got to be filed, and these proceedings are taking place. My lords, we had filed for discharge. Discharge was not allowed, and now the trial is taking place. But my lords, the unusual grounds here are those that I would want to underscore for your lordships. The unusual grounds are that certainly something has gone wrong. Something has gone wrong, and therefore your lordship's conscience would require that this matter would be taken to its roots, and the truth must come out, and people responsible must be held accountable. Well, lords, I cannot seek, in my particular circumstances, I cannot seek any special indulgence. The law applies to everybody and must apply equally to everybody. My only concern, my lords, is that the rigor of the law must not be specially imposed on me because of my circumstances. My lords, that's I only urge your lordships to consider that. But I bow that I must be answerable to the law of the land as it's been stated.
I think that is explicit enough. See, the court, in the eyes of the court, no one is high or no one is low.
My lords, I understand.
That we all know.
Right, my lords.
So, if you can specifically point out that you have been, let's put it this way, specifically targeted, then.
Well, I'm not going to go as far as to say that I've been victimized, I've been picked up. But there is certainly, when something goes wrong, there's a tendency, and your lordship will take judicial notice of that fact, there's a tendency to find a scapegoat, tendency to pinpoint something on someone. These are the very special circumstances in which we have come with this 482 before your lordships. Essentially, my lords, the issue is, the larger issue was that there was a large-scale interference, tampering in the result sheets, etc., right across the state. This is limited to 5 subdivisions. In 5 subdivisions, also there has been, clearly that's been established, that there has been some interference with the correct manner in which the results were to be tabulated. There's some interference. The issue, my lords, is one as to who's interfered. Then your lordships would very honestly say that this is a matter for trial. Who is responsible is a matter of trial. But my lords, before the trial proceeds, what does the charge sheet say? Does the charge sheet only assume that I am responsible? My lords, there are 3 accused. There are 2 matters before your lordships today. One matter relates to quashing. There are 3 accused. I am accused number 1. There's an accused number 2 who was the director of the department responsible for all the tabulation, preparation of results, etc. And there was another officer who was accused 3. Accused 3 has suffered serious case of dementia, as I understand, and therefore accused 3's trial has been set apart from my trial without giving me a chance. My lords, that's the second matter that can come up before your lordship. Now, to the extent that the trial is proceeding against accused 1 and accused 2, against the petitioner being accused 1 and accused 2, some evidence has come, etc., but we are not concerned with that. My lords, there the charge sheet specifically says, A, that some interference has been done. Fair enough. Who has done it? It assumes that the interference has been done by A1. A1, just in passing, because A2 is the focal point. And my lords, I'm conscious that I should not fall into the prisoner's dilemma that I accuse somebody and somebody accuses me and we both get into trouble. But the focus that I show to your lordships in the charge sheet is on A2. A2 is the person who was hands-on controlling, etc., after the selection committees prepared the results, the results had to come to A2. A2 then had to finally tabulate, prepare the merit list, etc., and then finally get approval at different administrative levels and finally the minister's level. Now, something may have gone wrong at A2's level, but it's not for me to say that it has gone wrong. Something may have gone wrong at A2's level, but the charge sheet doesn't show that what has gone wrong at A2 level is something in which A1 was directly or even indirectly involved. And I will explain, my lords, to the extent but the allegation, if at all the allegation is an allegation that leads to reasonable suspicion, does it go up to a grave suspicion, etc.? I'll address your lordships. But it's easily and lightly assumed that if A2 is to answer charges, A1 as the head of the department of A2 is also necessarily involved. This is an assumption which I believe the law doesn't allow them to make at this stage.
See, Mr. Khan, you have to understand, you see, what is the concept of complicity? The canvas is large. So, you see, within the ambit of that concept,
I understand.
many things can, many things can be included.
I would certainly address that, and I bow to your lordship that for a conspiracy, there isn't always explicit evidence available. It's to be inferred from circumstances. I bow to that, and I'll show that to your lordships in a moment. The issue that has arisen, my lords, is a very critical issue. Which,
by the way, Dr. Mozika, you are ready for the hearing? Shall we dispose it off at this
the copy was, I received the copy Friday evening, my lord, Saturday, Sunday being holidays. Lordship pleases, Lordship can issue notice today, my lord. In the meantime, I'll have instructions and it can be fixed on any date, my lord, final argument.
But again, Mr. Khan, as I've
but as far as
I've remarked earlier, see, can this matter be, can you come up with an application under 482? Is there no provision for appeal or revision or whatever? You've come up against, charges being framed against you.
That's right. We've come up against it, and that's 482. If your lordship wants to examine the issue of whether it should have come under 482,
that is for the respondent to
my learned friend could
another
respond.
aspect, the order, impugned order is of August 22, my lord. And after that, charges have been framed, my lord. Witnesses have been examined. Certain number of witnesses have been examined. Now, up to almost 9 or 10 months, my lord. That is one aspect your lordship will have to examine, my lord. And number two, my lord, when prima facie, the learned trial court has come to a conclusion that there is a prima facie sufficient material, my lord. May I just point out few paragraphs, my lord, on the face of that, my lord, whether your lordships will be inclined to exercise any kind of power under 482 at this stage, my lord.
Lord, in all fairness, my learned friend would have all these points.
My lord.
The only thing is, if with a flow of whatever arguments I am to place, I've already admitted to your lordships that I do realize that there is a barrier that I have to cross to persuade your lordships, as I would have to persuade any court that 482 is an appropriate exercise of power in such circumstances. But these are unusual circumstances, and I had explained, I didn't want to go into greater detail, unusual circumstances. Therefore, if the flow of my arguments are available, and then your lordships hears my learned friend on whatever objections my learned friend would have, I would certainly appreciate that.
What is your prayer?
My lords, my prayer is for quashing, but there is interim prayer for stay and so on and so forth, but your lordships may or may not consider that. Prayer is for quashing. Well, lords, if I may just show your lordships one interesting point, it'll just take a moment. If your lordships will see, as your lordship will see at page 68, this is the charge sheet. I'm just making one point. Sort of is the so. Well, lords, this is the charges.
Yes.
This is the charges. Page 66. It begins, and it goes from firstly, secondly, thirdly. Basically, forgery. And I'll address your lordships on the issue of forgery, also Sheila Sebastian, etc. But your lordship will then finally see at the end at page 68. If your Lordship will see at page 68, it starts at page 60. It starts at 68 and then it continues on 68A, my lords. There was one page missing. So if your Lordship will see seventhly, the charge, seventh charge, that you during the aforesaid period while functioning as Education Minister, Government of Meghalaya, being a public servant, abuse your official position in pursuance of criminal conspiracy with the accused persons and forged original score sheets by manipulating and tampering marks by using white correction fluid therein pertaining to selection of candidates, etc., and etc. And then finally, this committed an offence of criminal conduct which is punishable under subsection 2, section 13. And my lord, saying that I've actually interpolated and interfered, whereas the charge sheet says that you took everything onto your computer. We've taken the computer hard drives. The computer hard drives have been sent to forensics, but the forensic report has never come. And therefore, I'm being accused of something that I can't answer by saying that you have actually interpolated, having charged me in the charge sheet of saying that you have put everything on your computer and changed everything on your computer. It changes the whole complexion. I understand, my lords, that this would be critical as far as the trial is concerned. But as I said, in these circumstances, to place somebody under a cloud for 5 years, 400 odd witnesses, etc., would it be fair? My lords, would it be fair? And therefore, if my learned friend wants to reply in detail, I'll be very, very happy, so long as I can, with some fluency, place my case before your lordships. That's all.
Yes. But Mr. Khan, I think we'll since he expresses inability to conduct the matter today, we'll take it up on another day.
I appreciate that.
But and in any case, is there any other respondent apart from the
No.
prosecution?
There's no other respondents, only CBI. It's only CBI.
Okay. So you agree on the day?
Your lordships convenience anytime.
Tell me.
Your lordships are sitting in June, the first week of June is convenient to my learned friend. Because we'll be free from the Supreme Court, so I can
Nowadays, Mr. Khan,
your lordship's state will be very salubrious at that time.
That's for you. If you want to visit the state, well and good.
First week of June.
Otherwise, you can always appear online.
Well, it's first week of June.
So first is only first and second we are getting. First is a Thursday, second is a Friday. Yeah. So instead you can have in the next week 5, 6, 7, 8.
Yeah.
No, so any day, sir, no problem. I'm here, sir.
Would your lordships, if your lordship gives us a date, would your lordships wish to take both matters on the same day?
Definitely.
The other matter is about severance. Is about
even then that also.
So if my learned friend can take notice on both,
yes,
and then be ready for.
Yes,
fine. So on 7th, what did you suggest?
Well, my learned friend suggested 5th.
5th.
The week starting from 5th.
5th. Week starting from 5th.
Fine.
Any day that week.
So we'll take it up on 6th then.
6th.
6th is Tuesday.
Yeah, yes.
Okay, we.
Malus.
But Mr. S. Khan, the senior counsel, appearing for the petitioner. Dr. N. Mozika, learned DSGI, has accepted notice on behalf of the respondent.
Just ask her.
On plea made by the parties, this matter is to be finally heard on the next date fix. As agreed to, place this matter on 6 June for hearing.
Well, with my learned friend, the court requires the record to be here. I don't know.
I don't. Is it?
Your lordship, please.
There are two issues to be urged here. The first is the issue of maintainability, which this court will hear, and if you go by your, since you have annexed all the relevant,
they are here. They're all here.
I don't think it's necessary. Do you think it's necessary for the records? In any case, trial is going on. So this case, court will not want to disturb the trial.
Yes.
As and when required, we'll see.
Yeah, fair enough.
So 6 June then.
6 June, I'm deeply obliged.
Both the matters.
Both matters. Same order.
Item number 4.
Notice item number 4, respondent number 1 and 2, they are yet to file affidavit, my lord. It's taking for a long time, my lord.
Your Lordship, this is the same matter which I have appealed before the division bench. And the division bench has given an observation that either I go to the apex court or await the appointment of the new judge. And Your Honor was pleased to post at least 4 weeks' time on the last occasion. I would like to seek the indulgence of this honorable court to extend that adjournment, Your Lordship.
Because Mr. Sangesh, an observation has been made by a division bench.
Division bench.
So this court cannot.
But I'm very much aware of that observation. Now the law is very clear. They file an appeal, they exercise their rights. One of the judge recurs from the matter, so matter could not be even listed today. That observation is there. Until unless the stay order is passed by the appellate court or learned division bench, this court is not precluded from proceeding the main petition. Well, may I just cite one judgment, because in my absence earlier also this point arose. May I just please one judgment? I'll keep up to my senior also. With profound respect to my senior.
We are aware of this.
Well, this matter also, I'll not drop a lordship, but the law is very clear. This also the 2023 matter, law is the Honorable Court held that by merely filing an appeal will not preclude the trial matter, trial court to stop from proceeding to forwards. Therefore, my humble prayer as of today is that if lordship desire, lordship will give a last chance. Otherwise, the writ petition is pending from 2020, and the affidavit is not yet coming forward. If let the affidavit file by the senior as a last chance, my lord. Otherwise, my lord, this matter is lingering for filing affidavit 2 years, 3 years. That is really, my lord, too long for the petitioner. Too long for the petitioner.
I do agree that there must be an express order by the appellate court in the case of admission of the appeal. And I agree with that there must be an express. But sometimes we have to understand in the implied way also. If we're going to read section 9 of the CPC, it speaks about jurisdiction of civil court. In case of, it will have a bar in case there is an express or implied understanding. In this case, Your Lordship, the Honorable Division Bench has given an observation which has to be understood in the implied way, Your Lordship. It's some sort of a stay that you are to await.
My lord, Division Bench did not have the, my lord, did not entertain at all, my lord. Just express difficulties.
Yes.
It's difficulties only. There is no question of implied stay. There's a advance permit.
There's no stay.
There's no stay.
In deference to what has been observed, this court has allowed the matter to to travel at this pace, keeping in mind the prayer, the observation made, as well as the prayer of the respondent here, that the matter may be suitably heard by.
Yes.
Whatever appropriate bench available.
Whatever appropriate. Be that as it may, since the matter has travelled for quite some time, it is also appropriate that this matter may be heard and disposed of, for which any party would have recourse to, to go to higher courts.
That is there.
So that is the flow of things.
That is their rights, madam. That is I bow down for that rights available to them. But now I'm concerned, my lord, when stay order is not there, they prefer appeal in the month of August. Now we are in the month of June, nearly 8 months again, my lord, after preferring appeal. They know very well after they file appeal, the learned division bench explains its difficulties to move forward to entertain the writ appeal. It is a duty of the other side to cooperate with this before this honorable court and file the affidavit. If they don't want to file, it is their choice. I have no business, my lord. Lordship may record their statements. Otherwise, my lord, by merely filing appeal, but that will preclude the other courts. That is, my lord, the law here. I'm citing 2023 matter. It is very, very clear, very clear. Therefore, I'm not opposing that he will not deserve any further time. If lordship may give, if desired, but it may be a last chance, my lord. Last chance.
I think, Mr. Kanta, firstly you have to understand the issue of maintainability has been decided.
Yes.
Now that matter is closed. Now we have to proceed.
I agree with
and
that.
we have to proceed on the merits of the case, for which you have to file your.
Yes, Your Lordship. I do agree also that there is no stay, but we have to read this order, Your Lordship, in the correct perspective. This order is made to enable the appellant to take appropriate step in case there is any urgency. There is no urgency, Your Lordship, or await the next appointment in this court. That's not a vain statement or just a statement of the area. It's some sort of a statement that which wants to enable me to agitate before an appropriate bench.
When the word "or" is there, it means it may be, it may not be.
I will take instruction, Your Lordship, and
With
one last
great
chance be
respect.
given for 4 weeks time.
But 4 weeks are, my lord.
And,
My lord, I humbly pray, my lord.
we may-
I humbly pray. Indulgence has been, my lord, enjoyed by my other side, with great respect. And that observation I am also very much aware. The appellant was given a liberty. If your appeal is considered as very urgent, you may go to apex court. Or if it is not urgent, you may wait.
Await.
Await. My learned senior has exercised the second option. That doesn't mean that he will not, my lord, cooperate with these proceedings. He will not he cannot scuttle these proceedings, my lord. So, Lordship, may I give
I'll give you 4 weeks time. Last chance.
Yes, sir.
I will see to it how to go about it.
Yes, sir. Last chance.
Mr. G.K. Kanta, learned senior counsel, who is also the special counsel for the respondent KHADC, has submitted that he may be allowed to seek instruction as regard filing of the counter affidavit on behalf of the said respondent before this court. In view thereof, prayers allowed that the instructions so sought be carried to this court by way of either filing of the said counter affidavit or to decline to file the same. Any other respondents here? You, Mr. You are
My friend, he has filed affidavit.
You have filed your affidavit. Okay. As prayed for, this matter to 4 weeks.
Much obliged.
But it's the last chance, Lordship.
Last chance. I don't like to use the word last chance. Because
Last chance after last chance, second one. I'll see to it that
you see, it's always, you see, when
Lordship has decided to maintain
when there's an express opinion of the court that will be a last chance, please respect the sentiments of the court.
accepted. Good day. Thank you.
Much obliged.
Item number 5.
5. Ang dami na boy. Kapag sige hearing. Yes, what about this?
Your Lordship, both the parties are in the process of settling their differences.
Is there any
The
headway?
husband and wife.
Is there any headway?
Advocate? No. It's between the parties.
You are appearing for?
I'm the petitioner, my lord. The mother-in-law. Is there any positive development or?
Oh, there might be, because there is.
But how come you are not in a know? Yes.
Your Lordship, if this matter could come after tomorrow, or I may read as the leading counsel is inside indisposed, Your Lordship.
On premier by the petitioner, list this matter tomorrow. So these hearing matters, we'll take it up after. Now it's lunch. Yes, to the poll.
Item number 11, my lords, your lordships had heard this matter on the last occasion. This pertains to, my lords, appointment of the private respondent in a particular school. Now, the Advocate General had appeared, my lords, and your lordships had passed an order because they said that the post is advertised. On the last occasion, I brought it to your lordships' notice that thereafter, my lords, nothing has transpired. My learned friend was to seek instructions and place it before your lordships.
I think they have also filed an affidavit bringing the advertisement on record.
Only till the advertisement, my lords. That was last year.
Okay, what is the process?
Your Lordship, they are in the process of preparing the roster. The department is in the process of preparing the roster.
Then the roster
because
matter.
the advertisement was issued. Thereafter, the direction to prepare the roster came.
Okay.
So,
yeah, and all in the while, my lords, the private respondent is still enjoying that illegal appointment.
You should have.
That has to go, my
You
lords.
should have done away with the services of the respondent if she or he.
He, my lords.
If he has been appointed,
No, because they say, my lords, because the position becomes clear because they say that that post was never advertised. So once the post is never advertised, my lords, his appointment on the directions of some higher authority, as has come, my lords, becomes a purely perfunctory appointment.
Exactly. Because the school also cannot run without a teacher. So the school will suffer.
But then it would have to be an ad hoc teacher, my lords. I would be equally eligible for that post. While I'm not claiming anything at that moment, my lords, because of the stance taken by the state, but the private respondent cannot be a beneficiary of, my lords, some illegal act of the state, which they admit is an illegal act.
There is no interim order also.
Anyway, this matter is supposed to be heard.
So your lordships are coming back, my lords. We can take it up.
Not today, Lordship, because I'm appearing along with the Advocate General, Lordship. Maybe next week or 2 weeks, Lordship.
2017. I think I've made it clear that no more adjournment will be allowed.
Just show me the order sheet.
So we'll do it tomorrow, Mr. Paul. Tomorrow will be okay.
Tomorrow, then I'll have to inform the Advocate General, Lordship.
He is not in station.
He's not in station, but
he can appear.
I'll inform him if possible. He can appear through VC also.
Well, my only prayer would be that when the state is appearing before your lordships, my lords, they must have proper instructions as to what is the position of the private respondent in the school today, and why is it still continuing, my lords, in service. Because that would be in the teeth of the orders passed by your lordships on the last occasion, on the basis of the affidavit filed by them that there was no advertisement as against the appointment made now.
Yes.
No, because that is the reason why he's still continuing. Tomorrow is not available, Lordship. Day after tomorrow. Day after tomorrow, I'll
Wednesday.
So we'll hear on premier parties. This is matter on 3rd.
Right.
My lord, I beg to mention item number 9, my lord. Let it come next week, my lord. I'm not keeping well. I need some time for rest.
17 minutes.
So item number 9 next week on Monday, my lord.
Matter was not heard.
Not heard, my lord.
Not yet. Number of them, my friend.
But last time, so he said he is not well. So
Even now, my throat and my I'm under still medication, my lord.
1 week.
1 week time.
On premier by the Leonard Senior Additional Senior GA, Mr. S.N. Gupta, seeking accommodation on ground of personal difficulty. The same not being objected to by the petitioner. Matters adjourned. This is still after 1 week.
After 1 week.
What else is left? So this 14.
14 I am for the private respondent. My lord. This is a small issue, in fact, very small issue, my lord.
The petitioner, Your Lordship.
So we'll take it up after lunch.
Okay.
Your private.
I am for the private.
Then who's state?
They are appearing for the.
I'm for the petitioner.
Who is appearing for the state? First, we have to Mr. Sengupta.
Mr. Sengupta.
Yes, Mr. Sengupta.
I don't have the brief, my lord, but
Who is appearing?
I believe Mr. Guru.
Mr. Guru.
Mr. Guru is here.
What do we do?
It's a small issue, my lord. It's a very small issue.
But the parties have to be represented.
He's here, I think. Mr. Guru, my lord, he appeared in one case. He is around, I think.
So you inform. You inform Mr. Guru.
We'll try, my lord, because normally after he just rushes back home, he needs to go.
That should not be ignored when he rushes back home. The court is going on. How will he rush
cannot do
back?
that.
Sometimes he,
This kind of submission should not be made.
no, sometimes he leaves.
I will also rush home then.
This kind of unfortunate submission. We should not make this kind of submissions.
No, it's a fact. You might not agree.
Okay, so we'll take it up at 2:30.
Yes, yes, sir. Oblige.
You can inform Mr. Guru.
Yes, I'm trying. If it is your case, we'll inform.
Item number 14.
May I please, Your Lordship, because of some personal difficulties, my senior he have to leave. Can you fix the matter tomorrow, Your Lordship?
It is as expected. The apprehension was already raised by Mr. Sen. So tomorrow, on pre-made by the parties, this is matter tomorrow.
Highly obliged.